right, we're back. Hopefully, this is the last day we have to watch this damn trial. Hoping, praying. Let's start.
But since I've already given it, I'll just swap in 3903 and 3903A as already read, because I did already read these.
So you're going to keep the one that's been read already without the word saying?
When I did give these jury instructions, I gave them as they're printed out here. It's just without I think the proposed instructions had language that I struck out, so this is just a clean read.
The one that I submitted this morning is directly out of KC.
But you combine 3903 and 3903A. And that's not how I gave it. So if it had been given to me that way originally, I would have read it that way, but I didn't, so I don't want to change what I've already read.
Okay.
All right, 3905A. I think I already gave a version of that as well, right? Oh, maybe I didn't.
I'm not sure.
What is this?
That
I'm about to skip through what's not important.
3901, I think I already gave.
We ain't sitting here for 6 hours.
And plaintiffs is straight from the case.
Yes, sir.
And defendant had a different one?
They getting stuff together. Paperwork and stuff, it looked like.
Emotional distress was more longer lasting.
For example, Your Honor, have you heard?
Go ahead.
For example, they may find that there was an assault and battery and no intentional infliction of emotional distress. By removing the damages section, they would never be able to award any damages. So that's why I request that it at least be left there so that they could give damages to the parts that they wish to give. And counsel on both sides can argue duplication, don't give it twice, break it down.
Your Honor, that would be incredibly complicated, difficult to separate. It wouldn't work. I understand your position, but there needs to be some way of ensuring that there's not duplicative damages awarded.
Your Honor, they have multiple attorneys on their end. They created this form. If the court is going to go along with their form, then they should have to live with the form that they created.
The form that we've created does not have that risk of duplicative damages. Oh, I'm sorry. The other thing is that I think we've already established with the jury instructions that if there are not damages that are awardable under some causes of action that are.
May I add one more thing, Your Honor?
Go ahead.
Yeah, I'm sure the court has seen it in many cases where it is broken down. There's the damages award specifically for one cause of action, like in this case, assault and battery, and another one for intentional infliction of emotional distress. Closing argument, counsel obviously can.
Let's get to the damn closing argument.
That Dr. Sher died on March 5th, 2021. You remember, counsel.
Okay. Keep moving. We're getting somewhere.
Was the photograph. I want to be very clear that I intend to argue that in my closing.
That's not an evidence of it. I think what you said was they didn't provide the date. And you're fine, you can argue that they didn't properly authenticate the photograph in terms of the date.
Your Honor, the court said that I could argue this in my closing.
You could argue it. You could argue that they didn't establish what the date was.
And also that the All-Star game was on February 18, 2018, the week before. But the week before the incident, I don't see the harm in that. They can object to that. They can say their version, but that's part of my closing, Your Honor. And this photograph, by the way, this photograph was sprung at the last minute. It was never produced in discovery.
just briefly, a couple of questions. First, as if you remember, counsel violated a motion in limine order. And now he's talking about arguing things that are not in evidence, which is completely improper. I don't want to object every 5 minutes to his closing argument. I would ask that
He said he's sick of your shit.
the court doesn't want to tell him that he has to follow the rules. He can't argue out things that aren't in evidence. He can't violate the motions in limine.
I think it's readily apparent that you can't argue facts that aren't in evidence. I think plaintiff's counsel knows that. I think he knows that he would be violating the rules of professional responsibility.
Yeah, he don't care though.
Arguing facts that are outside the evidence that was presented in court. If he wants to present that and you want to object, then that's how we'll proceed.
Thank you, Your Honor. And then,
Are you done?
then two procedural questions. Does the second monitor work and can it be facing the jury so they can clearly see it?
I don't think so. We're in the middle of a transition and I don't know.
Okay. And
We can see it's not.
Your Honor's preference, we have demonstratives and we have things we're going to show, intend to show. Do we need permission to publish admitted exhibits?
No.
And do we need permission to publish demonstratives? They have been provided to plaintiff's counsel.
No. And it's argument.
Yeah, okay. I just want to make sure. Thank you, Your Honor.
All right. Anything else from plaintiff's counsel?
Yes, Your Honor.
Can y'all get to it?
Counsel has just stated.
Phones? Thank you for that.
Okay, he telling everybody to turn off their phone.
Thank you all for coming back today.
So at this point, both sides will be giving our closing argument, basically a summation of everything you've heard, just so you can jot down things, take notes if you feel comfortable. So you all heard all of the evidence in this case, and the distinction between a civil case and a criminal case are different.
All the
What
evidence
that
you
means
ain't got.
is in a civil case, our proof, what has to be in the box, is greater than 50%. Touch more than 50%. Maybe
So-
a featherweight more than 50%.
What?
51%. It's not 100%. The standard is a little bit more than 50%. In this case, you've heard lots and lots of testimony. We've had the plaintiff who's testified. We've had the plaintiff's mother who's testified. We've had the plaintiff's grandmother who's testified.
Irrelevant
Those three
testimonies.
witnesses explained their recollection about the scar. There was testimony that
They explained what they recalled having a discussion about her going to court to do. That's what they explained.
the scar, or the cut, came from this incident. That's a very, very important fact. There's really nothing to contradict that. If anything, our expert witness, Dr. Mulliken, you remember he came to court. He's a very well-respected doctor that specializes in plastic surgery. And his testimony was that, in his opinion, as an expert, that when the way that this scar, the way that this cut happened was from fingernails. And that there were 3 different scrapes, 3 different scratches. And that the middle one was the deepest one. And that's really the one that he worked on. Now, the issue in this case,
The issue in this case is that you showed nothing, you explained nothing, you gave no proof of nothing. And why are we here?
before I go to that, is the photograph that you saw, okay, which is in evidence. There's a photograph of the scar, which is a 2-centimeter scar. The photograph, because of the skin color, it does not show well in photos.
If I had some kind of scar on my face that was so affecting to my life, you'd be able to see it. And I'm darker than her. I'm just saying.
The cut that was on the face does not show up as well. So you may have to really look at it deeper than just had it been someone else. The other thing that I wanted to highlight is I really just don't understand. The defendant came here, used all of this foul language. This is a court of law. You cannot speak this way in a court. I have never seen this before. And for her to use all of those words, F word, B word, all these different words, it's a disrespect to us. It's a
You asked her to say those words and asked her to repeat it multiple times. So what are you talking about here? Now you're trying to throw that in there? Get out of here. You lost.
disrespect to the judge. It's disrespect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And
right, he told her to say the words. Hold on, what's she saying? What's she saying?
She did whatever she needed to do to become a licensed security guard. And she did that job. The thing that I wanted to highlight respect to this courthouse. You cannot come to court and say these kind of words. It's just disrespectful. And just because Miss also known as Cardi B, is a celebrity, doesn't mean that she could just say and do whatever she wants.
Get the fuck out of here.
People. Okay? If you recall,
she ain't attacked the court. Now you're trying to make it seem like she attacked the court. She disrespected the court. She disrespected us by using these words. Literally, you asked her to say the words and asked her to repeat them over and over again.
Just to give you a little bit of background about Miss Ellis. When she was 19 years old, she moved out of her house. She went to college. She's a college graduate. She has a bachelor's. She
Nobody care.
went on to become a security guard for 4 years, from 2014 to 2018. She did whatever she needed to do to become a licensed security guard. And she did that job. And when this incident happened,
all you gotta do to become a security guard is to take a test. I'm just saying. And pay for it. Just saying.
In 2018, that was cut off. She lost her future in security work, in something further, whether it's FBI, police, attorney, whatever she wanted to do.
Shut the fuck up. No, she didn't.
This incident cut it off. No more. Because of the trauma that she sustained. And I get it. There were doctors who gave their opinions. For example, the defense brought Dr. Rosenberg. Nice guy, gentleman. He complimented me. Maybe he's doing that because he's a psychiatrist and he knows what to say to twist everything. But the point is, he got $40,000 to come here and basically tell us that the plaintiff didn't suffer any emotional injury.
And how much did your little doctor get for giving his little examples of how her face was scratched? And he believed her face was scratched. We forget how much he got paid and how much he's still supposed to be getting paid. Why are you talking about how much that expert got? Y'all so-called expert got paid too.
That's not the facts. The facts are, Imani Ellis was working as security guard. There was a change. Okay, it's very, very traumatic to be assaulted and battered. I can only imagine the embarrassment, the emotions, the pain that Miss Imani Ellis suffered. Now,
She ain't suffering no damn pain. Only pain she's suffering is losing this damn case. and losing it in the public eye. Now everybody gonna know who you are, what you look like, and that Cardi B called you big. That's what she losing. This is what she losing.
Overwhelming testimony that Miss Ellis was working as a security guard at the time of the incident. There's no question. She was in full uniform. She had a badge on. Even the defendant admitted, yes, I understood that this person was. And there has to be some level of respect. These are not doormen or doorwomen. The defendant, when she came to the building, instead of listening to the plaintiff, to listening to her commands, you know, you got to do this, you got to do that, please leave the building, different commands were given to her, which none were followed. Instead, the defendant thought that, well, Miss Ellis was on her phone. She was telling people that I'm here. These were the thoughts that were going through her head at the time, and she's testifying.
Because she did say, oh my God, it's Cardi B. Cardi B is here. Oh my God. She did say that. Move on. You don't have nothing to say. You just say, I don't have nothing to say. I gave y'all what I had and I tried my best, which was terrible.
However, that's not the case. Miss Ellis testified that she's never had a fight before. She's never done anything.
We don't give a fuck what she said because she's lying. We don't give a fuck what her grandmother said because she lying. We don't give a fuck what her mother said because she lying. We don't give a fuck what that expert doctor said because he getting paid to sit here.
To harm anybody. She's never had any fight with anybody. And her mother and her grandmother also testified. She's a model citizen. She's a hardworking person. And she simply, her whole goal of doing this, to be here and sit here and go through this, is so she could move on with her life. Sometimes people have to.
So she could get some money and not have to do nothing she don't want to do now. Because she no longer can be a security guard. But I thought that ain't what she wanted to do. Didn't she tell somebody that she no longer wanted to do security? That's why she got something in the medical field?
Be heard. Be heard. So by you all being here and hearing everything that's
Go to work and work hard like everybody else.
Given her a sense of closure where she can move on and go on.
Something you was not doing as a security guard.
The next step and the next phase. She's only 32 years old and she has plans. She has plans to do other things in her life. So we're very thankful that you gave us that opportunity. Each and every one of you, we're very thankful. The other thing I wanted to mention is the phone. It would be impossible for someone to be videotaping someone and be on a phone call at the same time. I tried it myself. And
no, it's not. No, it's not. That's a lie. I don't know what kind of phone you got, but I can record somebody and be on the phone at the same time on my iPhone. I've done it plenty of times. Hold on, I need to take a picture of this. Did you get the picture? Did you get the video I just sent you? What are you talking about? Also, there's a such thing called a FaceTime call, where she could have already been on a face call recording.
The error message that you would get if you tried it is recording video is not available while on a call. So
that's not true. I literally can turn my call off. I can turn my, and he talking about why you on FaceTime too. It does that on maybe the camera sometimes, but I can go on a different app. If I turn my camera off, I can go on a different app. Or if I turn my camera off, period, I can still record from my camera. And I can go on different apps and record. Instagram, Facebook. I can go and record on those apps while I'm on the phone.
The two of them couldn't be done at the same time.
Yeah, and he objected to that. He said sustain.
Miss Ellis
Stupid ass.
Told Cardi B multiple times, I am not recording you. I am not telling anybody that you are here. I'm simply doing my job. And instead of maybe agreeing or investigating further, Miss Almanzar, Cardi B, got angry and started yelling and cursing and spitting on Miss Ellis. And
y'all never got to the part where y'all actually figured out whether or not she spit on her. So shut the fuck up with that part.
Calling her different words, using the N-word to disrespect her, calling her the B-word, calling her fat, anything to try to trigger her and make her upset and embarrass her. Sometimes...
And again, I do believe she called her fat. Probably called her a fat ass bitch.
Words are more painful than the physical. And to add insult to injury, she then cut her face and caused a scar on her face. And what happened then? Miss Ellis had to go see different doctors. The court did read about Dr. Scher a sentence that basically that there's this undisputed Dr. Scher died, and Miss Ellis
we don't care.
Testified.
We do not care that that doctor that she visited died. We do not care.
That initially, a couple months after the incident, she saw Dr. McKenzie, a psychologist, through her workers' compensation.
But she ain't see that doctor that died right after the incident. So why are you bringing that up?
Was given that. She got 7 visits with that doctor. During that time, she also saw Dr. Scher.
No, don't skip Mackenzie, because Mackenzie also said and testified on stand that nothing was wrong with your client, physically or mentally.
Plastic surgeon. Unfortunately, we don't have him here. We don't have his records because he passed away. So that's why that was read to you in open court, so that it's some sense of fairness. Why there's no records from Dr. Scher.
Objection, Your Honor.
Yeah, because you still could have gotten those doctor records. You still could have gotten those doctor records somehow through the medical records. And they should have actually been somewhere on a file for her to see and give you whatever proof you may have needed. You didn't even need that doctor to actually talk. Had she actually gone to that doctor for what you claim she went to that doctor for, it would have been on the medical forms that she has to view.
Then we learned throughout the case that when Cardi B came to the building, she caused a disturbance. She caused a disturbance. She was yelling and screaming at the top of her lungs, going crazy, yelling and screaming, to the point where 2 other witnesses, Miss Malcolm, which was the secretary of the doctor, and Dr. David Finke, was so loud that those 2 people.
And you making it seem like it was just Cardi B yelling. They said they were both yelling, and actually your client was the aggressor. Both the receptionist, Miss Malcolm, and Dr. Finke said your client was the aggressor. Why? He is terrible.
People came out after about 40 to 50 seconds. Now, the issue with that is those 2 witnesses didn't see the 4 things that happened before that, which happened in the 40 to 50 seconds before.
But what they did see is your client being the aggressor.
So yes, they're witnesses, but they're not witnesses.
Now
to
he's
that
saying
first
they're
part,
not
that first
witnesses.
segment, which
They're not witnesses. Neither was Granny or her mother. Those were not witnesses at all to nothing. Continue.
would include taking a swing at Miss Ellis, spitting on Miss Ellis, calling her the N-word, and ultimately cutting her face. None of that was seen by those two witnesses. So yeah, they're witnesses, but they're witnesses to the aftermath.
And none of it, not even the aftermath, was seen by her grandmother or her mother.
They're witnesses to what happened afterwards. They're not eyewitnesses. They don't know what really happened. And when they arrived, Miss Ellis was so upset. Can you imagine all those four things happening? Being disrespected, embarrassed, who knows what else happened? All of that was done to her, and she still was able to contain herself to a certain degree. But yeah, sure. I mean, naturally, she was.
No, she wasn't, because she was swinging on the receptionist. No, she wasn't. She hit the receptionist. Dr. Finke witnessed it. The two that you say were not witnesses actually got in the middle of the altercation.
Angry, she was emotional. So when these two witnesses come out of their offices, they can only see an angry person. They didn't see what led up to that.
If she was keeping her composure, then she still would have been keeping her composure when the doctors came out. More so because this is her job. Make it make sense.
And they had assumed that it's her fault, maybe, or that she did something wrong.
They
But
assumed.
again, those two witnesses didn't really see much. They saw something after the fact. And then you have Miss Malcolm, who decided on her own, this was her choice, to squeeze herself in between the two people. Well, that's a risk that she took. And if she
So now she took that. Look at Cardi falling asleep.
somehow
She's
got a
sleeping.
cut to her face or a scratch or
She falling asleep.
something, well, we don't know who did that. We really don't know.
Look
She
at
didn't
her.
do it. Miss Malcolm testified that
She better wake up.
she did not know who scratched her face. She has no idea.
See, that would have been us had I not skipped all this shit that they was talking in the beginning.
What does that mean? It could be from either one.
Let's
Could be
get
from
to it.
The commotion that's going on. These things happen so fast, we have no real idea as to what really happened. Unfortunately, there was no video.
She is
There
tired.
was no other witnesses.
Unfortunately, there's no video of this. There's no other witnesses. What happened to the pictures of the scar on her face that she said she had? Y'all can't really even tell us what happened to those. And except for, oh, she don't even have that phone anymore. I still got pictures from my old phones. Like, and if she got an iPhone, those transfer over to your new phone. So where her pictures go? I wonder if she got an Android. I'm gonna have to ask my mother about her Android phone. What can it do and what can it do? Cause, and also her mother didn't take no pictures. You ain't got no pictures? Her grandmother ain't take no pictures. She would have had one of them old cameras that the thing slide out. Like, you ain't got no pictures?
That actually saw it. So it really comes down to one thing. Do you believe Miss Ellis?
Where the Polaroids at?
Why not? You should. She's a hard-working security guard. She was doing her job with no prior anything. At some point during the trial, the defendant showed you Exhibit 232. You all remember this photograph? Exhibit 232. This is a photograph Now, the issue with this
A photograph of
is
what?
there's really no way to know the date that this photograph was taken. There's no way to know. We don't know when it
What
was
is
taken.
the photograph of?
There is no proof of when this photograph was taken. It could have been taken at any time, before or after the
You already said this. Shut up. Are you talking about a picture of her nails?
incident. It could have been, and in this case, the defendant testified that this photograph was taken on the date of the incident.
Objection, Your Honor.
No, she didn't. She didn't say that. She didn't say it was taken on the date of the incident. If that's the photo of her nails, no, she didn't.
That was her testimony.
She just said that these are the nails that she had. She didn't say that that was the date.
But where's the proof? Do you really believe that a celebrity can't prove when this photograph was taken? She testified that this photograph was taken at the All-Star, NBA All-Star game. There's no proof of that anywhere? That's just false. There is proof of when this photograph was taken. It just wasn't given to us. It wasn't provided to us. So we can't rely.
Why didn't you do your research? It didn't have to be provided to you. You should have did your research. And first of all, she did not say that it was that day of the altercation. Did not say that on the stand. But if you could prove that she had different nails on that day, and you could prove that that picture wasn't from that day, then you could have done that on stand and in your cross against her and proved her wrong. But you did not, because you did not do your research to see if that was even the same nails she had on that day.
On this photograph, because there's no date on this photograph.
She is tired, boy. Hurry up, talk. He annoying. Still
Another
trying to scrape
important
stuff up.
fact is, if a witness is not credible on one point, you can disregard their entire testimony. When you go back,
Okay, so they can disregard the mother's entire testimony, disregard the grandmother's entire testimony, disregard that doctor's entire testimony.
back into the jury room, you will have all of these different jury instructions. And each jury instruction will be there for you where you can read and understand what the law is and how it applies to this case. And as I told you before, testimony
He just
is
talking and
evidence,
talking.
and you can rely on
And
testimony
saying
alone
nothing.
to come up with your verdict. KC 107 states, do not make any decision.
They do not need you to explain the rules to them in your fucking closing statement. The fucking judge will explain the rules to them when they need the rules explained to them.
Simply because there were more witnesses on one side than on the other side. If you believe it to be true, the testimony of a single witness is enough to prove a fact. So in this case, you've heard from different witnesses. Just because one side may have more witnesses or less.
Oh my
that's not how
god,
it
now
works.
he mansplaining the
One
rule.
Importance, a lot of truth.
Skip.
There is no other doctor from the defense side. They could have spent money and hired somebody and had them testify here and tell us, yeah, Dr. Mulligan's work is no good, or she could have done something different, but we don't have that here. You have one doctor on the plaintiff's side basically explaining all of his
There was not just one doctor on that side.
expert opinions.
Yeah, just that. Yeah, he explained his expert opinions, but there were other doctors on their side that actually have witnessed and had freaking appointments and stuff with the client and said that there was nothing wrong with her. He need to move on. He irritated me.
And the other thing that I wanted to discuss would be the fingernails.
Oh my God.
Cardi B testified that most of the time she would have long fingernails, 3 inches. That's her style. That's what she did. And in this case, not only did she have these long, sharp fingernails, she also had rhinestones. If you remember Dr. Finke, he was a fingernail, that was his thing.
I said that was his thing too. He must like fingernails.
They were raised. Miss Ellis's mother, Leanne Schmidt, testified.
Oh my God.
She testified that Miss Ellis obtained the scar to her left cheek as a result of this incident.
Objection.
Miss Ellis's mother testified that she recalled seeing the scar after this incident. Miss Ellis's mother testified that she saw changes in her daughter after this incident. Same with Miss Ellis's grandmother, Diane Schmidt. She also testified that she recalled seeing the scar.
Yeah, the lady that see her once a month.
After this incident. And that she noticed a marked difference in Miss Ellis after the incident. That's her granddaughter. The defense put on a Dr. Rosenberg, who was a hired gun, received $40,000 for this case and makes millions of dollars in this type of work. He criticized the Kaiser Hospital for not writing down that Miss Ellis had emotional injuries when when Miss Ellis went to Kaiser Permanente for vaginal discharge.
Oh my God. Why he keep on bringing up her vaginal discharge? That's one doctor's appointment that she had. Just one. Under Kaiser. Not the rest of them. That you just conveniently left out. You gonna bring up just the one. About her doing something about some damn vaginal discharge.
2022, Dr. Rosenberg
We do not care.
Testified that there was an inconsistency when Miss Ellis went to Kaiser and didn't tell them about her emotional injury.
He didn't testify that it was about that specific one. And he couldn't even get out his mouth that he saw others. It wasn't just that one.
Why I'm bringing this up is very simple. When someone goes to an orthopedic surgeon, they don't talk about dental injuries. When someone goes to a gynecologist, they don't talk about emotional injuries. What really happens is when someone goes to a psychologist or psychiatrist, they tell them about their emotional injuries. When someone goes to a dentist, they tell them about their broken teeth. When someone goes to an orthopedic surgeon, they tell them about their neck pain.
Shut up.
Next, we heard from Dr. Finke. Want to talk about inconsistencies? There was an inconsistency between Malcolm and Finke. Malcolm said, I don't know how I got this scratch on my forehead. I don't know. Dr. Finke comes out and says that Malcolm told him that Ellis had scratched her face. That's not true. That was never said.
He said that he witnessed it and it had to be after the altercation.
So this, if you remember, this is a 7.5-year-old incident, and that's a few thousand days ago. It takes a lot of time has passed, and an incident can be perceived differently by different people. So Miss Malcolm.
He literally said and kept repeating that he witnessed her get hit
Malcolm could have perceived it one way, and Dr. Finke could have perceived it one way. But again, same problem with him is when he came, everything already been done. The whole incident already happened. The injury was already complete. And
you don't know that. And that's not a fact. I thought we were sticking to facts here.
really, this comes down to believing Miss Ellis. She gave you no reason not to. She's been truthful through me and through herself and through her witnesses to give you whatever is there, to provide for you all that she could with the things that she has available to her, so that you could give her the peace of mind, the closure, and yes, she is asking to be compensated for the loss that she sustained. She lost something, and by you compensating,
she lost it because that was her fault. Cardi don't owe her nothing.
Her with money damages, you're then evening the playing field. You're giving her what she lost back.
No.
So she's not trying to gain something that she's not entitled to.
She definitely wouldn't have been having no $24 million either, working as a fucking security guard.
Unfortunately, she was abused, she was harmed, she was assaulted and battered by Cardi B, and Cardi B needs to pay for that and needs to be accountable. We need to hold her accountable. We should not just let her walk away and say, oh, everything you did was okay, and yeah, do it again.
Now he trying to talk them into just giving her any little bit of compensation. No. She don't deserve shit. Not one penny. Oh, my bad. I ain't even see you over there talking. What's up? She don't deserve shit. I'm just down looking. What's up? All your friends is... What? September? Oh, I didn't know that was a thing. Ain't nobody subscribing anyways. I'll make it 25% off on Twitch, but ain't nobody over there subscribing. It's hard for me to get people to subscribe to my YouTube.
Miss Ellis also received another 12 visits. She testified that she saw a psychologist, Dr. Avila, and other people in his office.
Violation of the court's order.
I'm low-key skipping through this because I can't stand this man no more. He getting on my nerves. And I'm not sitting here for 6 hours falling asleep with Cardi B. Look at him, dead noise. He ain't got nothing to say.
And we want to make this wrong right. And how can we do that? Through each one of you. You have the power to make this wrong right and close the books for Miss Ellis so she can move on with her life as much as she possibly could. And yes, the only way to do that right now, for today's purposes, is to reimburse her for the losses that she sustained.
She does not deserve anything.
It covers...
He talking about all the medical bills and stuff.
Areas of this case. The first section A is the assault and battery. They are, in a sense, separate because the assault is the swing and the battery is the scratch and the cut to her face. However,
you keep talking about the cut.
Clear. Did plaintiff Imani Ellis prove all of the following elements of battery?
No, she did not. No, she did not. No, she did not. No, you did not.
Breaks it down.
And here he go again, breaking down what they gonna have to answer and stuff.
Miss Ellis with the intent to harm or offend Miss Ellis.
Let the judge do that.
Then you can go. Then question number 4 speaks
Oh my
about
God, I'm
expectancy.
skipping.
3932 basically, you got to award some kind of pain and suffering.
Oh my God, see? You gotta award some kind of pain and suffering. No, he trying to get just any little thing now because they lost. He know they lost.
It's required. Now, the amount would be up to you. A lot of times, some people say, well, 3 times medical bills, 10 times medical bills. This is an assault and battery. It's just not a simple car accident where it's just, you know, some bumps and bruises.
Don't bring up car accident because we ain't forget that she was also in a car accident.
This is a serious, serious injury. Very serious. And Miss Ellis has been suffering for the last 7.5 years. What kind of weight
Yeah, probably from that car accident.
do we put to that? What kind of number do we attach to that? I don't know what number you're going to attach to that. But for purposes of now, for example, you could write $250,000 for the past pain and suffering. This was a violent attack. She was violated. She has a scar to her face now. She's gone through all kinds of medical treatment
Ain't no scar on her face. We saw her face.
that she didn't have to go to. So much life was lost from her, time-wise. You can't get it back. All this time that she's lost and feeling embarrassed and all of that. What is the value of life? It's significant. We all went through the pandemic.
We all went through the pandemic. What that got to do with anything?
That after the pandemic, the value of life is much greater because we realize what life is really about. Future non-economic loss. Again, that's going to be for the 50 years going forward. You
50 years?
could pick what number you feel. Maybe you feel
None. Zero. Zero.
she's recovered.
Oh my God.
The award damages for this. Was Miss Almond?
We moving on. He's just explaining all the stuff they gonna have to
Why don't we just, I don't,
answer and see if they want to reward her damages and shit. I'm not listening to him.
want to do it now.
He pissing me off.
Well, I have to say something about it.
You don't. We'll discuss whether or not we want to set an OSC and we can address it then. Okay?
Thank you, Your Honor.
All right.
Backgrounds, and they have common sense.
Okay, this is her closing statement.
Good morning, everyone. I'd like to start by thanking all of you for taking the time to participate as jurors. This is how our system works, and it wouldn't work without jurors. And I'd like to thank you on behalf of both Cardi, my colleagues, and myself. I'd like to just mention quickly that counsel argued that Cardi swore and used profanities in the courtroom and that was disrespectful. Actually, all she was doing was repeating under oath what was said.
What he asked her to repeat.
Ms. Ellis, plaintiff, used profanities to describe what she heard. Counsel used profanities, and I have to admit I used profanities, but just to tell you what was supposedly said. Cardi has never gratuitously
He said, even I did it. She wasn't disrespecting nobody.
sworn at any point in this courtroom, and this suggestion that you should be prejudiced against her because of that.
Right.
It's just
Right, because that's all I heard.
and offensive. Last Monday, it seems like it's a lot longer ago, but last Monday in the opening statement, I told you what I expected the evidence would be, and I told you that you can treat my statements and counsel's statements as promises of what they were going to show, and that I would ask you at some point today to decide who kept their promises and who didn't. I also told you that I would have a second chance.
He did say that in the beginning. Because he knew they ain't have no proof.
Directly after all the evidence is in. The evidence is in. Witnesses have testified that exhibits have been admitted. And if you remember, the judge told you the first day that the way trials work is that bits and pieces of evidence come in. This is my opportunity to tell you how we think those bits and pieces come together and how they establish that Cardi, you should decide in Cardi's favor. First, there's a couple of things I'd ask that you keep in mind throughout the rest of the trial. If you remember, Judge Fusselman told you last Monday morning that the reason we have juries is because they have diverse backgrounds and they have common sense. He reiterated how important common sense was when he said, we just need you to exercise common sense.
Not everybody got common sense, though, and they get common people to be on the jury. Not everybody has common sense. Because the comments that I've been seeing, some of these, under these posts that I've been posting lately, just ignorant. Like, did you watch the case?
Is this witness being consistent? Is this witness saying things, something that doesn't seem true? And does this piece of evidence fit in with all the other pieces that have been presented in this case? I respectfully suggest to you that using your common sense, there's only one possible outcome in this case. And that is a decision in favor of Cardi.
It is.
Now, you'll be instructed that plaintiff bears the
And I went into this fully unbiased, like, damn, what Cardi do now? Like, who she done fucked up now?
burden of proof of establishing her claim. She must convince you that the evidence shows that by 50% or more her claims are valid. Now there's another way of putting it is, and you'll see this in the jury instructions that you get from the judge, if plaintiff fails to prove that her version of what happened is more likely than not what did in fact happen, you must decide the case in Cardi's favor. The concept of a preponderance of the evidence can be demonstrated by this slide. That's 50-50. That's where the plaintiff has put on as much evidence of as the defendant of a fact, and you'll see that that's where people talk about the 51%. But it is crucial to keep in mind that plaintiff doesn't start at 50%. She starts at 0. She has to raise that needle from 0 to 50% and more. She has to go beyond 50%, or you have to find for Cardi. Mm-hmm. Third, there is no dispute that there was yelling and some curse words in the hallway at the medical building around 1:30 p.m. on February 24th, 2018. But the judge will provide you with the jury instructions. In fact, he already has. That arguing, yelling, even using profanity is not something you can sue over. That's just part of normal life, and that's what we're supposed to bear. In fact, that would be crazy that someone could sue if they cause someone else to use profanity. The question really is whether Cardi ever struck plaintiff, and who caused this confrontation, who caused the incident. And the answer is that the evidence in this case overwhelmingly proves that Cardi did not strike plaintiff, and Cardi did not cause this encounter. As a result, plaintiff has failed to establish, by the evidence you heard last week, that by a preponderance of the evidence, more likely than not, that Cardi was the cause.
I can't say the evidence all the way proves that she didn't strike her either, but the evidence does not prove that she did what the lady saying she did. There's no evidence that proves that. And if she did what she says she did, you should have evidence of that. Especially if you're going to show us a picture of a scar on your face that's not even there. I'm
going to try and do this in a very organized fashion, and the way I'm going to do it is going to be demonstrated by this chart. And so we have on the left-hand side plaintiff's evidence, and then on the right-hand side defendant's evidence. Now, plaintiff started with her own testimony. Last Monday, she testified under oath. Importantly, though, in plaintiff's evidence, she never called as a witness either Tiara Malcolm or Dr. Finke, both of whom were present.
Objection, Your Honor.
Both of whom were present at this very time of the incident.
She's still falling asleep.
Now, plaintiff's evidence, plaintiff's testimony, and we should keep in mind that just because plaintiff says something doesn't make it true. Okay? She has her version, but the fact that she alone says it does not actually make it true. And later this morning, maybe stretch into afternoon, I'll tell you, or I'll identify the many inconsistencies in plaintiff's story over the course of this litigation, actually going back to February 26, 2018, when she did her incident report. In the meantime, plaintiff claims that she was assaulted and scratched or cut on February 24, 2018. The plaintiff did not see a doctor. She didn't go to an emergency room. She didn't call the police or make a police report.
Objection, Your Honor. Misstates the testimony.
And she
What you mean objection? She didn't. She didn't do none of those things.
actually testified she did not know if the scratch that has supposedly ruined her life was even bleeding. She
Right.
also testified last week that she didn't even put a Band-Aid on this scratch. What did she do? She claims that Cardi mauled her, basically, cut her
Right.
face, and this woman went home, and what did she do? She took a nap. That was her own testimony. She took a nap.
Look at Cardi laughing. Exactly. She definitely, like, the way that she was explaining and making it seem, the way that her attorney was making it seem was like she mauled her. That's exactly what I was saying. Like, she would have had to have mauled her. And if she mauled her, we would see the proof that she mauled this lady with them long ass nails.
On February 24, 2018, plaintiff just went home and took a nap, is corroborated by plaintiff's own T-bill, cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls, and she makes calls from 11:20 a.m. all the way to 3:35 p.m., and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021 she hit her head in a car accident. She's put on no proof that wasn't the
Cardi trying to rock herself awake. She falling asleep.
source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021, is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulliken. She went to plastic surgery 4 years later after being in a car accident.
Exactly.
Misstates the testimony.
That's what happened.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another
And she had
lawsuit.
another accident
Plaintiff
and filed
has-
another lawsuit before that. So, what took so long for this one?
argued, and he said again today that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California.
That's all you need to do. You just take a test. Well, you take some class. You take a test. Well, you have to pay for it. You take a test. And then if you pass the test, they get your fingerprints done. And you get a card that says you're a security guard. I got one too.
That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside.
Thank you. I said that. I said that. Did she know that Cardi B was gonna be there?
Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape.
That's what I said. Was she waiting to get some flicks in? Didn't I say that? I'm about to go post that right now.
She would then be able to post it on YouTube, maybe start a new career, be a follower. I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do.
Exactly.
But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tierra Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses.
They were not
they
there.
testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives, and we hope our parents believe us, and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay? We all know that parents are not with their children.
They ain't got none.
We all know
I
that
feel
children
lying for
don't
her.
always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi, half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, Plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out. Because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no.
Mm-hmm.
So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay? Well, that sure doesn't square with the testimony of Tierra, Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her supervisor, Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek. But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there's something wrong about what's going on. Because, again, apply common sense.
Exactly.
Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked,
Exactly.
did you notice after the incident that the money
Bro, why do I feel like he be watching my videos?
had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020?
Exactly.
And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday. Question, you didn't call your grandmother though, did you? Answer, no. Okay? So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there, and they're relying on what plaintiff told them.
Exactly.
Now, plaintiff's
Everything I said.
third group of witnesses is Dr. Mulliken. Okay, that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24th, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years
4 years
after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars.
Everything I've been saying, he is saying right now. Bro. The 2 turned to 3.
Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar. That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide.
You saying you still ain't gonna see a scar with it in your hand?
The photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay? That's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show the. Okay, then let's show. This was played.
Did he just say no?
This was played for the jury before. It's Cardi's testimony. Excuse me, plaintiff's testimony as to how she was supposedly.
I don't hear no objections over here. Mighty quiet.
Cut.
When you say it like this, she put her finger.
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and 2 other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claim scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with a straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about how well-respected he is, that it was a right-handed person who scraped 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claim scar, but that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claim scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claim scar was caused by an intervening accident or some other cause.
Objection, that misstates the testimony, Dr.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And, Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulliken's testimony.
He said we also got the transcript.
For example, he calls a 3-minute-long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session, in his mind, is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional...
Exactly. He can charge more money if he say he doing a surgery. That's what I said.
$11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing. Even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000.
Cardi look like she got to pee.
Dr. Mulligan testified he is the sole owner of the surgery center with that operating room.
Shaking a little bit.
So he has a strong financial incentive to use and charge for that operating room, whether
She
he's
stopped
doing
now.
real reconstructive surgery or microneedling.
Her leg was shaking.
Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulligan also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulligan, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face.
Terrible
that,
scar.
You can decide whether you've seen it. If you've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulligan also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford
She don't got no money to pay him.
$20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulligan. Dr. Mulligan knows that he is going to get paid, if at all, his $17,500, only if his testimony helps plaintiff recover money in this case. That is a big incentive, and because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018 she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated, and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned she made an appointment with the obstetrician for Saturday afternoon. Let me get to. I'll
He
get
almost
to
done.
Cardi testified that
He keeping his
she
short
got
and
off
sweet
the
and to the
elevator
point.
to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop, and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi.
Damn! Damn, he just... Now, who gonna call him fat phobic? He said she's a large woman. She's like twice the size of Cardi B.
Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots.
Straight out
and
with
starts
it.
yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest.
He just called Cardi Skirty. Skirty.
With Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop.
Oh, they're gonna have a break.
I can stop there if you're okay, Lex.
All right.
Okay.
Well, stop there, folks. We're going to resume back at.
All of this, just break. Y'all could stop the damn live and come back after the break. That's why you need people that know what they're doing. Look how long it went for. Y'all just got people with cameras pressing buttons. They don't know what they're doing. They could have been stopped the live and just came back.
In this courtroom, that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tierra and Dr. Finke, who said that it lasted...
Who also said it lasted about 45 seconds to maybe a minute.
45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is, in fact, left-handed, and we've talked already about how that undercuts Dr. Lanikin's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star weekend. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day
No, she
of
didn't.
the alleged incident, on February 24th.
No, she didn't.
That's absolutely untrue.
Thank
She did not
you.
testify.
Everything I be saying, bro. Everything I be saying, he just bringing it right back up. Everything.
Right to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not, in fact, testify
Exactly.
to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently coffin square means the shape and a square and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy and they had no sharp edges. Apparently you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I don't know about that. But the point is, rhinestones can appear on a fingernail.
Don't be talking about Finky. We going to Finky to get our nails done.
Decorated fingernail, either as three-dimensional or as flat, which of course flat can't cut anything. And she testified, as did Dr. Finke, well, excuse me, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have two witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault, and if it is an assault, it's an assault by plaintiff on Cardi.
Exactly.
Cardi was being pushed back.
She was
And
backing up.
The testimony from all both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense, or that she cut plaintiff. The point he's overlooking is that is up to you. We've heard the evidence. We think it's overwhelming.
It sure
that
is.
Cardi did not touch a plaintiff at any point in time and did not touch this magic appearing, disappearing scar.
Appearing,
But
disappearing
we
scar.
have to be careful as lawyers. So we've included a self-defense, a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is an assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection.
Okay.
I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both.
Both the right, because the receptionist and the doctor said that they heard the lady saying that she was gonna fuck Cardi up.
Cardi's testimony, Tiara's testimony, Tiara Malcolm, and I believe also Dr. Finke. But let's talk about.
My
Ms.
memory
Malcolm,
be on
Tiara
point.
Malcolm. We called her as a witness, so we'll add her there. And she is one of the 4 people who were in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before, and so again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started.
They should have showed the jury what the place looked like too, to put a stamp on a point. Show the jury what the office looked like.
Counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now, we have a visual rendering based on plaintiff's own photograph of the hallway outside the dock.
Yeah, yo! And my stepfather just finished telling my mother that I should have been a lawyer. I don't want to be all extra professional. I want to be able to say what the fuck I want to say.
His office, and based on the testimony and Cardi of Ms. Malcolm, this shows how far. You see the elevator bank, and you see the doors that are depicted in the photograph that the plaintiff showed you.
Cause shit, they be talking about Cardi B was disrespecting the court by using profanities and shit. I've been disrespecting the fuck out of this court, if that's the case.
Plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner.
Okay. So they was over here in the corner. This is where the elevator was. And this is where the offices are. So she was going in, Cardi was coming out, and she was recording. And then Cardi was looking, because she did say she didn't know where she was going. And that she turned around, and then she saw the lady was following her. So Cardi probably started walking the wrong way. And turned around, realizing there's doors on that side. But this lady is still behind her. And then was probably talking crap. And the lady is walking into her. She said the lady was backing her up. And the lady said she came out of the office and saw Cardi in the corner.
Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them, with Cardi behind her and with Ms. Malcolm facing plaintiff. The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with the plaintiff. Ms. Malcolm took Cardi into the office, and someone else at the office, this is what she testified, what Ms. Malcolm testified to, someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not
the brouhaha.
With Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head.
Right.
Counsel has argued
Your
that...
Honor, I would object to him referring to counsel. We can talk about facts, not counsel.
Plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay. And he dwelled on that a lot in his cross-examination of Ms. Malcolm. And with all the things flying with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head. But she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with
Miss
plaintiff.
Ellis.
Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threaten in no uncertain terms to harm Cardi.
Who is almost double the size of Cardi.
Quote, I will F your
If y'all over there on my YouTube, don't forget to subscribe and like. Thank you.
That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face-to-face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face.
Spittle.
Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that since she testified here that she was using earphones. We've got another witness who says plaintiff was sitting there, standing there, flailing away with her
phone in her hand.
With her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Cardi and Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked what about chest to chest, and Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm
Cardi
also
is tired as
testified
fuck.
that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support her claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt that plaintiff was at fault and, quote, she handled everything unprofessionally.
Unprofessionally.
Now, we also called Dr. Finke. He, too, was there the day of the incident, and he, too, has no axe to grind. He is not her regular doctor and never...
And he was not getting paid to sit on this stand like them other experts, doctors were.
...has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NBA All-Star Weekend, and was concerned. She was pregnant, she wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling, and he immediately ran to the front. Okay, so he gets there very quickly, too. And he just has a little bit more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what, that's what happens when you try to help. I mean, really? I mean, you know, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway, and that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched Ms. Ellis, plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out, and also that Dr. Finke, once he got plaintiff to leave, which he refused to do, that he went back into the office, so he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood in her face from a scratch that supposedly ruined her life.
That
he
ruined
also
her life.
testified that he saw no spit or spittle on her. He
Spittle.
also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, I will F your S up. Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor.
Fat and poor.
Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails.
3-inch long nails.
An interesting term. That was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails.
Yeah.
And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him.
Exactly. That's what I kept saying. Finke and the receptionist got her fired. Cardi B did not get her fired.
His practice administrator that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired.
Exactly.
Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist.
They did their research.
Once again, common sense.
Exactly. There's something wrong with
We
her.
had a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe that evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. plaintiff who testified, if you remember, that incident reports are very important.
Yep.
And she testified, and in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's, with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek.
Nothing about her cheek.
And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's
Clearly
saying,
false.
and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Allied and the building owner, quote, for behaving the way I did. Okay? Why would she apologize to them if she was attacked? Why is it...
For behaving the way she did.
Again, common sense. She was apologizing because...
And in court, she acting like she ain't do nothing. She just was so proper about everything, and Cardi B was just in her face.
Because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
Counsel, you can wrap up in about 10 minutes.
Can I have a little bit of extra time since counsel got extra time?
I don't know that he did, but please try to wrap up.
He did have a lot of extra time.
I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is
The judge said you really don't need to. You proved your point.
an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKinnon testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie
It's so hard for him to say her name.
Plaintiff made no mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching.
Almost.
Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. And in response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that she if she saw the patient and saw, if they've got a cut or a scrape or a bruise or whatever, she people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome, and we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at her client. Now it's, well, maybe it was an accidental.
Right. That's what I said too. Like, he talking about some, maybe could you have possibly spit on her when you was talking? That's the only thing he asked Cardi B about spitting on that woman.
Spittle, say it, don't spray it kind of thing from junior high school. There's no evidence that happened. But it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened. We'll skip you over to Section B. We ask that you answer question 5, no.
Never did anything wrong in her life. She was a model citizen, good person, and she basically was doing her job as a security guard, and the defendant refused to cooperate.
She was doing her job as a security guard. Oh my God!
Assaulted and battered her.
Why he back up?
Took a swing at her, and ultimately, a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire
I know she tired of him.
Between Imani Ellis and Cardi B, and it really is going to come down to who do you believe? Who do you believe? Are you going to believe Imani Ellis, who was a security guard,
no,
who did her job,
no, she didn't,
who never had any problems of any kind?
You have to prove that she did her job, which she didn't.
Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your
Honor. What?
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word.
She did not.
Disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish.
Oh my God.
Try to get a reaction out of her. I don't know how it was that Imani Ellis was able to contain herself. Maybe because she is so peaceful.
Hurry up and sit his ass down.
Testimony about how she was
sit this man down.
The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this scratch, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person. Either one.
Yeah, after what he said didn't fit y'all narrative.
Stand, She said she was disabled because she was pregnant, but at the end of the day, she wasn't disabled with her hands, and you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a basket. In baseball, you must use the correct. No, this injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again,
I could see if the lady said she was backhanded and Cardi B had on a bunch of rings. Maybe you could have got some kind of scratches on your face like that, girl. But no.
The evidence that needs to be brought forth needs to be proven by a preponderance of the evidence.
Shoot, he making me tired too, Cardi. He annoying.
Featherweight more than 50%. In this case, we have given you so much different evidence from different people.
No evidence at all.
Imani Ellis,
So much different evidence and no evidence at all at the same time.
her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Imani Ellis should receive to make
Nothing.
her whole. And
Not nothing.
counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Imani Ellis was assaulted and battered, and we thank you for your service.
No, you have no evidence at all. Overwhelming evidence.
Thank you, counsel. All right, ladies and gentlemen, that concludes the presentation of evidence and argument.
Thank you.
We're now going to be shown to the jury room. We do have a hard stop at 4:30, and by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room, so please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But
She may do to them because of what she did.
What? Why is he talking again? They about to go on break, ain't they?
And counsel, do you see the door's closed? There it is. Okay. All right, we're still on the record outside the presence of the jury. We do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses? Were you sitting? Yeah, you.
Me?
Yes.
Oh, they asking the jury question.
Were you
He complained about jury talking to people.
outside? Did you sit next to the plaintiff's grandmother on Wednesday?
The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said, if I did.
Okay, so she didn't say anything.
So did you have a conversation with her? It sounded like you did.
I didn't say anything about this.
Nothing about the trial?
No.
Okay, very good.
Not at all.
Vanessa's going to excuse you to the jury room. All right. Thank you, ma'am.
I'll take your notebook
Thank you.
and then I'll take your.
Thank you.
How they know if she telling the truth? All right, now they on a break.
That were rude.
We're going to bring in the jury. Back in the record.
All this time just to do this. It could have took them only 2 hours. Come on with this empty space.
Miss Ellis was harmed.
Okay, they about to start talking. Verdict reached. Let's go.
All right, can the clerk please read the verdict?
Superior Court of the State of California for the County of Los Angeles. Imani Ellis, plaintiff, versus Belcalis Marlenes Almanzar. Cardi B, does 1 through 50, inclusive defendant. Case number 20 STCV 07031. Verdict. We, the jury, in the above entitled case, answer the questions submitted to us as follows. Section A, assault and battery. Question 1. Did plaintiff Imani Ellis prove all of the following elements of battery?
No.
1. Defendant Belcalis Marlenes Almanzar, Miss Almanzar, touched Miss Ellis in the intent to harm or offend Miss Ellis. Number 2, Miss Ellis did not consent to being touched. Number 3, Miss Ellis was harmed or offended by Miss Almanzar's conduct. And 4, a reasonable person in Miss Ellis' situation would have been offended by the touching. Answer, no. Question 2, did Miss Ellis prove all of the following elements of assault? Number 1, Miss Almanzar acted with the intent to cause harmful or offensive contact with Miss Ellis. Number 2, Miss Ellis reasonably believed that she was about to be touched in a harmful or an offensive manner. Number 3, Miss Ellis did not consent to Miss Almanzar's conduct. Number 4, Miss Ellis was harmed. And number 5, Miss Almanzar's conduct was a substantial factor in causing Miss Ellis's harm. Answer, no.
No.
Section B, intentional infliction of emotional distress. Question 5, did Miss Ellis prove all of the following elements of intentional infliction of emotional distress? 1, Miss Almanzar engaged in extreme and outrageous conduct beyond mere insults, threats, indignities, annoyances, hurt feelings, or other trivialities that a reasonable person is expected to endure. 2, Miss Almanzar intended to cause Miss Ellis emotional distress. Number 3, Miss Ellis suffered severe emotional distress. And number 4, Miss Almanzar's extreme and outrageous conduct was a substantial factor in causing Miss Ellis to suffer severe emotional distress. Answer, no.
This was a sham.
Section C, negligence and contributory
Whole circus.
negligence. Number 8, did Miss Ellis prove all of the following elements of negligence? Number 1, Miss Almanzar was negligent. Number 2, Miss Almanzar's negligence caused Miss Ellis to suffer physical harm rather than only emotional distress. And 3, Miss Almanzar's negligence was a substantial factor in causing Miss Ellis's harm. Answer, no.
No.
Section D, punitive damages. Question 12, did you answer question 4 and 7? Answer, no. Signed this date, September 2nd, 2025, by foreperson George Uloa, number 3.
All right, is it in Mr. Polidri?
No, Your Honor. Yes, Your Honor.
All right, let me ask the foreman, was it unanimous as to all the questions?
Yes.
All right, so
Yes.
the question that the clerk is going to be asking is, was it unanimous as to all questions?
Question 1,
Or just all questions?
as to all questions?
Was it
Yes.
unanimous?
Was it unanimous?
Yes.
And then go through each of the jurors. Was it unanimous?
Was it unanimous, juror number 1? Yes. Number 2?
Yes.
Number 3?
Yes.
Number 4?
Yes.
Number 5?
Yes.
Number 6?
Yes.
Number 7?
Yes.
Number 8?
Yes.
Number 9?
Yes.
Great.
11?
Yes.
And 12.
Yes.
Unanimous.
It was unanimous verdict as to all questions. Can the clerk please record the verdict?
The verdict has been recorded, Your Honor.
All right, thank you. Ladies and gentlemen, thank you for your time. and
Waste of
dedication to this
time.
case. I know that you've paid a great deal of attention throughout the matter, which was especially evidenced by the questions that you did submit. I want to thank you for that time and attention on behalf of myself, the parties,
For that time of paying
as well
attention.
as the people of California. As I indicated before, this system does not work unless people like you are able and willing to serve, and so I want to thank you once again.
Thanks for
Throughout
having
the trial,
common
I've
sense.
admonished you that you could not discuss the case with anyone, including other jurors. And at this point in time, I am relieving you from the admonition. You
Now
can
they could
speak,
talk about it.
with anyone about the case from this time forward.
They probably happy as hell.
I suspect that there's going to be not only the parties that will want to speak with you, but I suspect also the members of the press are going to want to speak with you. And so I'm going to tell you this. I'm telling the members of the media this, and I'm telling the parties and their assistants that it's
I
up
don't need
you
to speak
whether
to
you-
none of them.
whether or not you want to speak with anyone. If you don't want to
We
speak with
see
anyone,
why they
then you
came
can
to
just head right
the
out the
conclusion
double doors, out the elevators.
that
If there's
they
press
came to.
outside that want to speak with you, you can just walk past them. Don't let them stop you. If you do want to speak with them, then go ahead and you can wait outside the double doors. We're not going to be speaking with anyone in the courtroom. And if you do speak with someone, please be respectful of the views of any of your other jurors in terms of the deliberations. You can speak with respect to your point of view and how you saw the case. And the other admonition or the other issue with respect to speaking with people is that it's got to be at a reasonable time and place. And so if people start bothering you, or if people reach out to you that's inconvenient for you and they continue to do so, let me know and I'll take care of it, okay? All right. All right, with that, once again, I want to thank you. You are now dismissed.
Lovely. Dismissed.
Yeah, leave your...
Okay, yeah, everything is over. Thank goodness. 'Cause that was long for nothing. This whole video was 6 hours and 16 minutes. I did it in 2. Just too much. All right. And I'm about to go. Gotta get some stuff done. So I'm about to go. Don't forget to follow me on my YouTube. If y'all are over there, don't forget to subscribe and like. Gracias. Have a good night.